This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 5th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi there, my name's Steve Wayne. I'm a Director of Trademarks at Murgitroyd in London. And I'm joined today by Rebecca Dobson, a Director of Trademarks in our Southampton office, to discuss IP rights in social media. Social media is probably the fastest growing marketing outlet that there is currently today. Over a third of the world's population actually has a social media account, including Facebook, YouTube, and Twitter. We need to really be careful how we use social media, and we also need to be very aware of what other people are doing on our social media. So Rebecca, welcome. Have you had any experience yourself of problems relating to social media?
Hi Steve, thank you for inviting me to join you. It's a very interesting subject matter, particularly for trademarks and intellectual property, because it's so fast moving. There's such a tangent kind of quick turnover with a global reach, and it's cheap and it's easy to use. So it's used an awful lot, and increasingly so. Certainly in both of our careers, we've seen a massive increase in it and its reliance, and how that impacts both the trademarks that people are using and registering themselves and the infringement that arises from that. So I think it's becoming increasingly important, and perhaps one of those areas that's overlooked and not actually taken as seriously. It's not as traditional as the label on a product or something like that, but it's as equally as important for intellectual property, and firstly, your own rights, and secondly, not infringing others. What's your experience been, Steve?
I mean, I think that's an excellent summary of the position. Basically, I think what a lot of people don't realise is that trademark rights act exactly the same way with respect to a Twitter account as they do to something appearing on a label, something appearing on a website. It's not quite the Wild West like it used to be, but social media does have its own set of rules with respect to how people think it can be used. I think what would be very helpful for people today is if we were to discuss maybe what we can do to make sure that our own use is actually acceptable, and also what we can do to prevent third parties from using our marks on social media. I personally have had instances where a marketing company has decided upon a campaign without clearing it with a client and used a hashtag, thinking that it's absolutely acceptable to just put a hashtag in front of another party's trademark. Obviously, there is a question there as to whether or not that is trademark infringement. So I think the most important lesson, first of all, is that you must realise that trademarks are just as effective on social media as they are in the quotation real world. So, first of all, I think the first key element that people must do is, if they are looking to use a marketing slogan or anything else on social media, they have to consider whether or not they have trademark protection for that slogan, for that name, for that word. And if they don't have trademark protection for it, should they be looking for trademark protection? Then I think that they should be carrying out checks to see whether or not it is actually a registered trademark for another party. So what you do not want to be doing is launching a campaign using your very special hashtag and then find out 5 days later that you're infringing somebody else and that you have to take that marketing campaign down. Rebecca, what are your thoughts with respect to what other steps people should do before they actually launch a campaign on social media?
Well, I think a lot of it comes down to making sure that there's appropriate auditing of campaigns before they're launched. As you say, it's very easy, as we've been discussing already, it's very easy in the social media world to be very quick, very dynamic in how you're trying to launch something or use something on social media. That's the nature of it. And sometimes that can be done by potentially a junior team. It can be done without forethought of the regulations and things like that that are done, all these are subject to, whether that's trademark law or advertising or whatever it might be. So I think the first thing is, as an internal aspect for companies, is to make sure that there is a check process in place to make sure, exactly as you say, that firstly, if you can register it, And secondly, if it isn't, to check that nobody else has it registered and you're not going to be infringing somebody else's rights unnecessarily, which means you have to take down the whole thing. There's nothing more demeaning in a social media and media-driven world than having to retract that hashtag that you've just launched or campaign that's just been launched with great pizzazz, and then having to retract all of that with an apology to whoever's rights you've just infringed. So I think it's very easy to be swept along with the ideas without necessarily having those checks and those processes in place.
And I think that's a really good and key bit of advice with respect to anything regarding your trademarks, not just social media, but any type of use. You really do need to have a centralised body, if that's one person or if it's a department or even if it's just a liaison with your trademark attorney. You need to have someone who is aware of these potential problems, that everyone knows that they have to discuss these things. So your marketing department doesn't go rogue and fire off a new marketing campaign without actually checking that it's okay, so that you don't have product development designing or naming something which is not acceptable. And, it extends to patents as well. So I think that's a key bit of advice with respect to anything relating to intellectual property. With respect to social media, obviously, you're quite correct. The speed at which marketing takes place, it very much follows trends, means that there really does need to be that person that people know that they have to discuss this with before they go ahead. I think internally, you even have to look at educating your workforce, especially your marketing department, who may not actually have much interaction with intellectual property. It's often commonly the case that an R&D department will know about intellectual property because they'll be aware of patents, but a marketing department won't. So that education of your marketing department, indeed, you might have a separate social media team. They should also be very aware of the rights that you own and the rights that you don't. So it really does come down to education. And again, this is where a really good relationship with a registered trademark attorney can come in very handy, because the registered trademark attorney can provide very quick and concise advice if you have a good reputation built up.
And also have access to the necessary databases and search facilities to be able to check both nationally and internationally, because of the global reach of social media and some of these campaigns. It's important to remember that even though you didn't target it specifically in the UK, it may be that something else arises of somebody of some use elsewhere that then comes across, starts to get used in the UK, and actually as the source of all of this, you might end up in hot water. So I think exactly as you say, Steve, it's making sure you've got that registered trademark attorney who has access to the relevant databases, can have even a cursory initial check if it's having to be done at great speed, or full-on checks to cover jurisdictions and various other considerations before you end up in that hot water. And of course, Steve, we've also got to consider that the use of influencers and third parties these days has increased massively. There's a whole new world that has emerged where effectively you're entrusting the use of your brand to a third party. Now, as trademark attorneys, that almost brings us out in a cold sweat. I'm sure you've written up various agreements in your career, as most of us have, where we've purposefully tried to stop third parties using trademarks, and now people are actually actively doing it with their blessing. And how to keep control of that and make sure that, again, as you say, without a rogue marketing department, you equally don't want a rogue third party influencer who starts using your trademark that's going to either damage your reputation or accrue goodwill and reputation in some aspect that you really don't want. I don't know whether you've had any experience of that, Steve, but I think it's increasingly a problem.
My clients have been fortunate enough not to have too many problems to date, but I think it's something that people really need to bear in mind, especially with today's culture, that what would once have been something that would never have been considered would be actually to have a marketing campaign that targeted 50,000 to 100,000 people in a specific area. That is now what is happening due to the rise of the social influencer. You are now looking at people having a very specific target audience of those people who follow them. And previously, you might have used someone very famous who could reach out to 14 or 15 million people. Now, you can actually have a very cheap marketing campaign where you supply some free product to 10 or 12 influencers who will use that product and talk about it on their channels, on their Instagram, on their Snapchat, whatever they may be using, to a very actually limited audience, between 50 and 100,000 people. But times that by 12, and you're now looking at over 1 million people being exposed to your product for a very cheap return. But the problem with that is previously you dealt with one person. You dealt with the celebrity, you dealt with the sports star. Now you are dealing with 12 individuals, some of whom still live at home with their parents, but they are talking to a significant audience, 50,000 people. And if they are not putting the right message across, then you are having damage done to your reputation to significant amounts of people. So it really is something that is going to become more and more important, that any deal that you may do with an influencer has to be very much tied into a more formal, standard and traditional almost agreement, license agreement, whereby that person will agree not to make certain comments and not to do certain things that would damage your reputation. And of course, then you also have the problem of that influencer may go and say something on a completely different subject, which is completely wrong, and their reputation is damaged horribly. And of course, your reputation could be damaged as an adjunct to that. So it's something that really needs to be considered before making that entry into the social influencer market. But unfortunately, for some companies, it has to be done, and they may even have to take on that element of risk.
And I think going back to the education element, it's important that the influencers, if you're going to engage them, understand those aspects, but also that they understand, if it is a registered trademark, how to use a trademark appropriately. You and I have had it drilled into us over many years as to the definition of a trademark and how it's a sign that's capable of designating a certain undertaking for those goods and services. Well, does an influencer genuinely understand that? And are they going to use it appropriately, such that if it's a hashtag making use of your registered trademark, for example, is it being used in a trademark sense? Is it being used correctly? Or are they jeopardizing your registered trademark by potentially making it generic or some such thing that would potentially jeopardize the validity of your registered trademark? So I think education of social influencers is an important aspect as well. It's not just about jumping on the latest trendy bandwagon, launching a quick campaign and hopefully making a marketing dent for whatever reason. It actually needs to be considered and done appropriately. So I think it sounds great, it sounds brilliant, but it needs to be done with your eyes open, and let alone copyright that exists in anything that's attached, whether it's photographs or emojis or whatever it might be. There's potentially other aspects of IP law that need to be considered, and hence it is important to incorporate your IP attorney, trademark, copyright, design as appropriate to be able to educate. We're not saying that we're going to be there checking every single element before the button is pressed, but in educating, then it's important to understand where the dangers are and hence where we can help and where we can avoid mistakes.
I mean, I think educate is a fantastic word there. Not only educating, like you say, your own workforce, your own company, your own marketing department, but also those outside agencies, influencers, and any other links that you may make through social media, just to be sure that even if you are doing everything correctly, what you really don't want is the damage that can be caused by somebody outside of your company actually making use, which is still going to hurt your own reputation and brand. I think we've probably scared people enough with respect to the use that they're making. And of course, one of the other problems with social media and it being spread across not only the whole planet, but also across so many platforms, is the danger of somebody else using your trademark that you are actually not authorizing in any way, shape or form. Somebody using a hashtag maybe to drive views to their YouTube or Twitter account, using one of your marks as a hashtag and potentially damaging your reputation without you even being aware of it. So I think it's a good idea maybe at this point to move on to the idea of what we can do to actually police social media and what we can do with respect to problems that we do find. I personally have in the past had to trawl my way through Twitter and at the time Facebook with regard to the fact that we knew somebody was using our client's trademark, and this person had created, I think it worked out at 12 different accounts. So 12 different accounts, and basically with our client's trademark and USA or Inc. or some the following descriptive word. So it wasn't fun, but this was in the day before you could actually have that done electronically. There are companies now who will scour social media for you for references to your trademark, and it's certainly something that a company should probably consider if it's an area of business where people will try to make use of their trademark to drive views to their channels. I don't know if you've ever had anything similar.
I certainly had to take down accounts and things like that, and the good news from that aspect is if you've got the registered trademark, it is generally a very easy process now. Most of these large companies have very good IP complaint procedures, and it's generally quite easy to do that, but on the one proviso that you have the registered trademark. So it's again important to talk to your attorney to work out whether the mark is capable of being registered, what you can do to get it registered if it's not immediately going to be acceptable, whether that's through acquired distinctiveness of use or other routes that could allow the mark to be registered eventually. But if you have been through that process and you have it registered, Twitter and the like are generally very good at taking down infringing accounts where the mark is being used. It's harder within posts themselves, so within a campaign, because Twitter or whichever platform it is might not be directly accountable for that. It might be trying to track down the person actually responsible, but the good news is that, as you say, firstly, you've got companies who can monitor for infringing accounts such as that, and secondly, that you can apply to the relevant platform and get them to take it down relatively quickly and easily. Is that your experience as well, Steve?
Yes, it is. It is. I think there is a great difference between a deliberate attempt to possibly produce counterfeit products or to deliberately infringe, i.e. to use your mark to drive sales of a competing product. I think the difficulty I have found has actually been, like you say, where it's within a post and it's actually being used to drive views. It's not necessarily being used to drive sales. So somebody may use your client's trademark to drive people looking for that trademark, looking for that hashtag to their YouTube channel. And that can actually be a little bit more difficult to attack and to take down. But you do have options, sometimes even with respect to unregistered rights, but certainly having a trademark registration is of great assistance. And I think it's possibly a dirty little secret within the trademark community is that a lot of the people who are doing that type of thing are actually smaller businesses, individuals, people who aren't even using it in a commercial sense, but receiving a letter from a lawyer might actually be enough to make them stop doing it. Now, you do have to, of course, consider that there is a possibility of a PR disaster, as people like to say, if that person turns around and says, oh, I was threatened by the big scary company. But at the same time, there is that need for you to actually make sure that your reputation is not being damaged. So in a lot of cases, my personal experience is that if you go in, not necessarily in a heavy-handed way, but, you know, did you know this was a trademark registration? You shouldn't really be using it. Then I think I've often found that people are willing to change, willing to stop in return for us agreeing not to take any further action. And again, I think if you don't go in too heavy-handed, you can even avoid the possibility of PR problems, because a simple, almost pleasant note asking you to stop doing something is not really a story for your local newspaper, whereas a cease and desist letter with 5 pages long and undertakings and threatening to take people to court is more likely to appear on the local news. So it is a slightly more difficult thing to do, where it's not an obvious case of somebody actually trying to rip you off. Somebody trying to use your reputation to build their own is a little more tricky to deal with. I don't know if you've had any different ideas of how to deal with that, or if it's the same as I personally have found, which is in a lot of cases it's someone who is very small and really isn't actually looking for a fight.
I think there are 2 main considerations there, aren't there? You've got the genuinely innocent infringer who really was, and I did some work for a charity, there was somebody who was using their mark, but it was actually to raise money for them. It wasn't done in the traditional sense of the fundraising thing that, you know, it wasn't a sponsored run, it wasn't a cake sale, it was a slightly more ingenious way of raising money. Now, a little bit of research meant that we discovered that that person was actually genuinely trying to raise money for this charity. And hence, as you say, a friendly 3-liner saying, actually, can we just talk about this and work out how you're using the mark so we can make sure it complies with us, rather than going heavy-handed with the 5-page cease and desist letter. That would have been wholly inappropriate and could have been, as you say, a PR disaster. And that was all obviously amicably settled because it wasn't intentional. It was just through a lack of knowledge. Versus then you have most of them are just a fly-by-night way, whether it's innocent or intended infringement. But many of the intended infringers, even that, it's a case of they're after the quick buck. So actually, if you threaten, if you're seen to defend your brand, if you're seen to actively be looking and enforcing it, then they move on to the next person, because although it's not a solution, it doesn't stop the person doing it forever. It stops them doing it for your brand. And sometimes that's a very efficient way, both financially and in timescale, to get them away from your brand and free for the revenue to come back to you, and the damage to the reputation or whatever it is you're trying to stop happening in the first place. Is that the 5-page letter might be appropriate. But I think from my experience, it would be research who is behind it as best you can, find out what is going on. And yes, potentially, if you're still not quite sure, then potentially a friendly approach in the first instance. And if that is not effective and doesn't get a response, which if it is innocent will happen very quickly, if it doesn't get the response you want, then follow up with a nasty letter, because that may well push them onto an easier target.
Yeah, I mean, I think a really good idea is to have a plan in place, so that almost a checklist of where are we going with this. So if you see some sort of breach on social media, you first of all have the checklist of, do we care? This person has 4 followers. No, not really. Yes, this person's got 800,000 followers. We really don't want this to continue. And then, like you say, have the research idea built in, so that that is the very next step, to make sure you don't make that mistake of sending off a very threatening letter to someone who is actually, trying to do something nice. Or I have literally had someone tell me that what they were doing was an homage to my client, which I thought was great. I thought it was one of the best excuses I've ever heard. Oh no, I was honouring them. and the worst thing was he was absolutely genuine. He didn't understand that by using the client's trademark, he wasn't honouring them. He was actually costing them sales. But again, I don't know that going in very heavy-handed with him would have been a great idea, because he was very apologetic once he'd realised what he'd done. So you have that research element where you find out what is the correct tack to take, and then to make sure that you have someone who is following up with that. Again, it's often the trademark attorney, outside counsel, but also someone within the company, because to be honest, you can have things set up with your trademark attorney to deal with problems, but then you could find yourself having your trademark attorney wasting time on something that you then realise isn't a problem. So having a set plan in place, I think, is really, really important.
Yeah, and it saves time and money for everybody, doesn't it? If you've got that structure agreed, and as you say, there's a route through it, because time is of the essence when you're dealing with some of these infringements. You don't want to be hanging around trying to decide whether that person is too much of a threat or not. Either they're in one of those categories that you've predetermined, and that triggers route A or route B or route C, whatever it is, because this world moves very, very quickly. This is something that you need to take a reaction to very, very quickly and have an impact before damage happens. As Steve, I think our main message is education, isn't it? Is making sure that your team know a bit about IP. And we've certainly, I know you have, and I certainly have been involved in education sessions with clients to educate their teams appropriately. And whether that's either us in person or online facilities. I know our Murgitroyd team are fantastic at producing podcasts and awareness sessions and things like that can help. So please, our main message, I think, would be to get in touch with us to work out how we can do this to make sure that our clients and the wider audience don't get into hot water. Would you agree?
Oh, yes, definitely. Speaking of social media, there are various social media outlets for Murgitroyd where you can find a lot of really good information, and also those contact points to find someone at Murgitroyd who can help you not only with your current portfolio but your future needs. It was great talking to you today, Rebecca. Thank you very much for spending some time with us to discuss this ongoing and growing part of the marketplace. If anybody does want to talk to Rebecca or myself, you can find details on murgitroyd.com. And thank you very much.
Thanks, Steve.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.